the document. Do they still have any liability? Yes. Said no other than former Chief Justice Enrique Fernando, one of the most brilliant lawyers produced by this country. Justice Fernando wrote, in the case of Berenguer v. Carranza, 26 CRA, (26 CRA 673), promulgated in 1969. The lawyer had, in the preparation of the fake document, the lawyer had nothing to do with it. And therefore, the charge of deliberate deception obviously cannot be sustained. But, the court went on, would that of itself entirely exculpate him from any responsibility? The answer must be in the negative. Maski hindi mo sinadya, maski hindi mo naintindihan na peke pala yon, pag na-introduce mo yan evidence at natuklasan na peke pala, ay may pananugutan ka pa rin pala. As was correctly pointed out in the complaint, his failure to exercise greater care did result in the confusion and prolongation of the suit. Kasi nalilito kami eh. Under the circumstances, it would be to err on the side of undue leniency if he would be held blameless. He had incurred liability. His fidelity to his oath as attorney was less than entire. Every member of the bar must be on his guard, lest through oversight or inadvertence, the way he conducts his case or the evidence he presents could conceivably result in a failure of justice. Even if there be no intent to deceive, therefore, a lawyer whose conduct, as in this case, betrays inattention or carelessness should not be allowed to free himself from a charge thereafter instituted against him by the mere plea that his conduct was not willful and that he has not consented to the doing of the falsity. The Supreme Court found him guilty and issued a penalty of reprimand with a warning that repetition of the offense will be more severely left with. This is the ruling of the Supreme Court. Pinalta na ba natin itong mga ruling na ito? Pwede na pala ngayon, maski media ka, pwede mo nang i-narrate sa korte na hindi mo naintindihan kung tama yun o totoo yun o binigay yan ng PR, ng Dirty Tricks Department na kung sinong PR firm. Come on! Wake up! We all know how politics is done in this country. Just because you admit that this is a quasi-political proceeding does not mean that we can turn this into completely political circles. Kaya, I submit to my colleagues, I respect you, submit to these colleagues, my colleagues. What is the role of media while this trial is pending, while this trial is sub judice? Pababayaan na lang na ba sila na magbibigay ng kung anong lead dyan na identify tayo isa-isa. Itong mga senador na ito, pro-Aquino ito. Ito naman, pro-Corona. What does it say of our integrity? Pabayaan lang ba sila? Libreng-libre ba sila? In the name of freedom of the press? I think we should think very carefully about the sub judice ruling. While a case is pending in court, there is a gag rule. No person may orally or through other means, by media, for example, comment on the merits of the case. Even we are not allowed to do that. Shall we allow media to do that? Nilista tayo isa-isa, dito kaliwa, dito sa kanan. May kaso dito Ay di kung ganun gala, if this is going to be trial by publicity, let us invoke the Constitution and ask for a change of venue. Perhaps out of the country. We all know that the Constitution itself recognizes that public opinion can be so prejudicial in a pending trial that under the Constitution, the Supreme Court may order a change of venue. Ganon katindi ang ayaw ng korte ng public opinion that will teach lawyers who have trained for 9 years to become lawyers on what the law is or how it should be applied by people who have never applied the law in trial court. Kung ganito ito, huwag na tayo magbasa pa. That is all, Your Honor. Thank you.
Thank you. Now, may I now state the position of this humble presiding officer, and this position is subject to the opinion of the court, of the Senate sitting as an impeachment court. The Senate, it is by the humble view of the presiding officer that the Senate as an impeachment court must at all times observe the rule of law. It cannot transgress any of the applicable provisions of the Bill of Rights. It must be guided by the presumption of innocence before the pronouncement of guilt. It must at all times observe the principle of procedural and substantial due process. It cannot use its power to issue compulsory processes to compel any witness to appear and testify, and in testifying is forced to commit a crime. It cannot compel a witness to testify against himself. It cannot arbitrarily declare a person guilty of contempt and deprive that person of his or her liberty. It cannot violate the laws passed by Congress, of which it is an integral part. That is the humble position of this presiding officer of this Senate sitting as an impeachment court. Now, as far as the subpoena duces tecum involved, which was issued by this presiding officer upon the behest of the prosecution, this presiding officer assumes full responsibility for issuing that subpoena and is ready to defend his position in any court of law if there is a need for that. I will not pass the buck to the Senate sitting as an impeachment court. It was my decision as a presiding officer, and I am personally bound to assume the consequences of my action as a presiding officer. Having said that, I do not wish to delve on the issue of whether the exercise of the power to issue compulsory processes by this court in this particular instance involving Republics Act 1405 and Republic and 6426. I do not want to make any pronouncement on that because precisely this court, through this presiding officer, exercise the discretion to heed the request of the prosecution to issue a subpoena duces tecum to help them obtain the evidence they wanted in the face of proscriptions by laws of the land passed by Congress. And that is the subject matter now of the case before the Supreme Court, filed by a private party asserting its rights under the law of this country and under the Constitution to be protected from any liability. And that is the reason for which the Supreme Court issued a TRO. And that was also the reason why this court, or a majority of this court, yesterday ruled in an open and influenced voting that this court must respect the order of the Supreme Court to issue its temporary restraining order, whether or not